Good morning, everyone. This is Michelle Barki at Medcom Benefit Solutions, and welcome to the second installment of our ACA webinar series. And today we're going to talk about acquisitions under the Affordable Care Act and what employers should know. Now, first of all, I want to give a legal disclaimer that this information is intended for educational purposes only and does not constitute any legal or tax advice. Whenever needed, our clients, if you're in a merger situation or an acquisition situation, you should always be talking to your own legal counsel. Now, the agenda today, we're going to talk about the difference between a stock sale and an asset sale, because there are lots of different issues there. We're going to be concentrating today in this presentation on applicable large employer determinations when it comes to acquisitions. And we're going to give you some examples, and then we will have a question and answer session. So let's talk about the difference between a stock sale and an asset sale. In a stock sale, the buyer purchases the selling shareholder's stock, and it's directly thereby obtaining the ownership of the seller's legal entity. So the seller no longer legally exists, and the purchaser buys it all. With an asset sale, the seller retains possession of the legal entity, and the buyer purchases individual assets of the company. And they can actually, pick and choose as to what they are actually buying. So how does that all pan out? Well, with a stock sale transition, it can only be used to sell an incorporated business. So the business has to be incorporated. The buyer is going to assume liability for the seller's plans as a matter of law. So all the group health plans and everything that goes with it is now assumed by the buyer. And the new business is actually passed to the new owner, including the name. And they also assume any liability for ACA reporting if it wasn't done, or for the employer shared responsibility penalties that might come forth. So with a stock sale, the buyer gets the business, but they also assume the liability. Now, the buyer does have negotiating powers in order to determine how the seller's plans will be affected after closing. They could shut the plans down. They could do a whole lot of different things, but the buyer has the negotiated power now because they are actually in control. Employees typically maintain all seniority. So if you're transferring everybody to the new company, those employees have seniority. You can't consider them new employees. This is important because, as we know, coverage must be offered on day one to full-time employees if they are an applicable large employer. And the seller has the option of writing off the entire price paid from the sale using lifetime capital gains. So there are some financial whiz-bang issues as well when you're looking at the stock sale and transactions. And again, it's really important in a stock sale that everybody understands that benefits are out there, the applicable large employer determination, the lawyers need to be looking at potential liabilities because that buyer is going to be assuming everything, and potentially that is part of the negotiated price tag for the group. Now, in an asset sale, you can use it in any type of business. You can use it with an incorporation, a partnership. You can do it which way you want. You can do it for all businesses. And it allows for the discretion of what is actually being sold. It could be a very limited sale, or you could sell all the assets to the seller. But again, we're selling assets. So the seller does not typically assume liability because they're just buying assets. But because of this successor employer concept that has come out, the buyer needs to negotiate protections through indemnification provisions. Let me tell you, the IRS is not going to care who they're coming after, as far as employer shared responsibility. You buy the assets, you find out that they never did the reporting or they owe all this money. It's pretty hard for the IRS to say, I'm not going to come after you. So we need to always look at indemnification provisions where the seller is actually going to still be responsible for anything that comes up. But because the buyer doesn't automatically assume the seller's plans, the buyer can actually negotiate the future of the plans as well. And the buyer can shut down shut down sellers. They can just, shut down everything. They can shut down the EIN numbers. They can shut down everything of the buyer. And the buyer's employees typically are terminated from the seller, and they're rehired by the buyer as new employees. They do not maintain their seniority, and taxes are paid through capital gains tax. So again, there's a difference between an asset sale and a stock sale, and that becomes important when we look at applicable large employer determination. Now, what is a state of confusion? And I know Derek has covered this a few times on his webinars with Recharge. And you're going to see that we are going to be very much in a state of confusion when we talk about applicable large employers and acquisitions. And the state of confusion is a state of being bewildered or unclear about something. And when we look at these ALE determinations, when it comes to an acquisition, let's see if the shoe fits. And when it comes to acquisitions and mergers, there's a large law firm, the Mintz Company, and they said when it comes to mergers and acquisitions involving at least one applicable large employer, the substantive rules governing employer shared responsibilities and the corresponding reporting rules share at least one thing in common. We don't yet know how they work. So again, we are always going to be in the state of confusion. So let's go back and look to how we determine ALE status to begin with. Applicable large employer status is defined as having 50 or more full-time, including full-time equivalent employees on average for the previous year. So we're determining 2024 applicable large employer status based on how many employees we had in 2023. And did we have 50 or more full-time, including full-time equivalent employees? And you have to count all members of the control group. And if they all together have that 50 or more full-time employee count from the previous year, then each of the members of the control group or the affiliated groups are part of an ALE, regardless of how many employees they have. So you could have a control group that has 5 members in the control group, and each of them have 10 full-time employees. Well, altogether, they had those 10 full-time employees in 2023. They are an applicable large employer, and each member of that control group with their 10 employees are now an ALE. Now, the government did say that businesses not in existence for any date in the previous year who are expected to have 50 or more employees in the current year are considered an applicable large employer for the first year of business. So I am a restaurant. I come into being on July 1st, and I'm opening up a pretty big restaurant. So I anticipate having 50 full-time or 50 full-time employees in the calendar year of 2024. That is my reasonable expectation. So when I open the doors on July 1st, I am an applicable large employer, and as an applicable large employer doing business, and I'm going to have to report in the 2024 tax year and 2025, and I must satisfy the mandates of the Affordable Care Act. Now, for the second year, we don't have to rely on that reasonable expectation of having 50 or more full-time employees, including equivalents. What we do is we look at the total employee counts from July of 2024 through December, when I was in operation for this year for the first time, And then did I average 50 or more full-time equivalents and full-time employees and full-time equivalents? And that's going to determine whether or not in 2025, I am an applicable large employer. And I no longer have to rely on this reasonable expectation. Now, when it comes to mergers and acquisitions, this is what the final Federal Register said when we're talking about applicable large employers. They said, as with the proposed regulations, the final regulations reserved with respect to specific rules for identifying a predecessor employer or the corresponding successor employer, or in short, they reserve the right to make the rules, but they have not yet. They said the Treasury Department and the IRS continue to consider development of rules for identifying a predecessor employer or the corresponding successor employer. And then until further guidance is issued, taxpayers may rely on a reasonable, good faith, and interpretation of the statutory provisions of predecessor and successor employees for the purposes of applicable large employer determination. In other words, we have to look at everything that's happened, look at how we've handled things in the past and what other laws are out there, and then make a reasonable determination. And they did give us a hint that they said we could use how we handle those wages for employees when we're paying taxes, such as social Medicare and Social Security taxes, where there's a limit. So again, they gave us some guidance, but it really did not happen to the gamut of the Affordable Care Act. So here are some of the scenarios that we run into. The seller and buyer are both applicable large employers when the merger or the acquisition comes together. Okay, that's pretty straightforward. Or the seller and the buyer did not have 50 or more full-time employees, including full-time equivalents the previous year, but combined in the current year, they have over 50 full-time employees. Or the seller did not have 50 or more full-time employees, including equivalents the previous year, but the buyer did. And then the seller had 50 or more full-time employees, including equivalents the previous year, but the buyer did not. So we have the various scenarios out there when we have a merger, and how is this going to be affected? So I want to talk about these various scenarios and whether or not it's an asset sale or a stock sale. And I want to mention that these are not written in stone, but this is what the reasonable interpretation of the many different employers have come up with through their legal departments, and basically what we have talked about. But again, we are still in that state of confusion, and this is not written in stone. So let's start with the first scenario. If the seller closes down and the buyer hires employees, can they treat the employees from the seller as new employees? And even though it might not be wise, and this is the seller and the buyer are both ALEs, so I will start with that. So in an asset sale, if the seller closes down and the buyer hires employees, can the employee from the seller, can the buyer actually treat these employees from the seller as new employees? And the answer is yes, because on an asset sale, they terminate the employee under the seller, and the buyer now hires them, and they can be considered new employees. And you can then put them through the measurement period or the waiting period. Now, again, it might not be wise to do that from a morale point of view, but you certainly can, and we see this happening over and over. Now, the seller is responsible to report under their EIN until they're sold, so they would report, these are my full-time employees, I offered them coverage or I didn't offer them coverage. And then let's say the takeover was July 1st. After July 1st, they are no longer my employees, 1H2A. And then the buyer would pick it up and say they would buy employees from January to June. And then in July, I pick them up and they're my employees. Now, in an asset sale, the seller's full-time employees are considered ongoing employees. Because again, you're buying the company and the employees are considered full-time employees. So if you have a situation where both of them are ALEs. When you transfer those employees over to your group, you are going to offer them benefits or continue their benefits. They cannot have that interruption. And the buyer is technically responsible for all the reporting, and he's also reliable if they did not report. Now, it could be that they're reporting them under two separate EINs, and we would mention that on the 1094. You know, we've got two EINs, and they weren't employees under this EIN, you know, they were employees under this EIN, and then we would potentially terminate them and then report them under the other EIN. But again, they're technically responsible, so they've got to make sure that they have all the information to do the reporting. Now, they can contract this away and tell the seller to do it, but if the seller is no longer in business, makes it hard. Now, what about the seller and buyer did not have 50 or more full-time employees in the previous year? If it's an asset sale, it can be argued that they did not average 50 or more full-time employees the previous year, and therefore neither of them were a control group. However, a more conservative approach has been that when we established this new company, we established a new company basically, and that even though we didn't have 50 or more full-time and full-time equivalents in the previous year, potentially this year we do, and that we're operating a new business, and therefore we really should be considering that they are an ALE on the date of the acquisition. And then in reporting on an asset group, you can certainly say the seller has the obligation of reporting, and then the buyer has the obligation of reporting afterwards. But because they weren't applicable large employers, are you actually reporting, and when do you start that reporting with that more conservative approach? So again, we often see it argued, though, that the employee did not have, neither of them averaged more than that 50. But now we're talking about a stock sale. And if the combined total of the previous year was more than 50 full-time employees, if we follow the rules outlined in COBRA, they would say that they were an applicable large employer on day one of the year that they were actually purchased. However, the more robust approach, and what seems to be flying more, is that, you know, it's not really fair to say on January 1st, we are an applicable large employer. If we went between the two groups prior and we didn't offer benefits, should we be penalized? So in this scenario, the other approach, which seems to be the one that's followed, is that, you know, we formed a new business in July, and therefore in July, we are an applicable large employer and we must offer coverage, and then we'll be offering the buyer would actually do the reporting in January. You know, in the next calendar year, they would do the reporting for that tax year. So here the seller did not have 50 or more full-time employees the previous year, but the buyer did. So the buyer has always been an applicable large employer, but the seller was not. So if you have an asset sale, if employees were acquired by the buyer, you can treat them as new employees, as we've said. They terminate under their old employer. Now they're hired by the new employer, and you can put them through the waiting period. If the EIN is kept, however, again, the buyer is going to do the reporting. They've kept the EIN. They're going to report under the EIN if they had been offered an offer of coverage. But a lot of the times, if the seller did not have the 50 full-time employees, the buyer would just put it under the EIN. I mentioned on 1094 that the acquisition went through like in July, and then they would be reporting on them after July, and under that EIN, they would try to figure out how to do the coding to indicate that they did not offer coverage. And the reason being is that they weren't an applicable large employer, but as of July, they were. But buyer would report after requiring the group. Now, in a stock sale, those sellers' full-time employees are considered ongoing employees again, and they must be offered benefits on day one. And the seller becomes the ALE as part of the control group on day one. And the buyer is technically responsible because they're assuming the liabilities for reporting under the buyer's ID for the first part of the year. And when the seller becomes the ALE as part of the control group, then they would report on the employees under the new EIN. And then the seller has 50 or more full-time employees the previous year, but the buyer does not. So now we have the seller with the full-time employees and the buyer does not have them. Now, on an asset sale, the buyer now may be an ALE as a newly formed corporation because they, now they become, they bought something that's now an ALE. So there's always that argument, although there's also the argument that they're not. Seller will be responsible for reporting for the months the prior sale, and the buyer is responsible after the sale. So again, we always have to look at it. Another way we see this happening is that a lot of the times they'll wait till the end of the year in order to make the final purchase so that the buyer, the seller continues the plans, they continue the employees, and then only after the asset sale is complete in December will they actually move all the employees over so that there's not that much confusion. But in the stock sale, if the combined total the previous year was more than 50, then again, under those COBRA regulations, it would look like that the buyer would be an applicable large employer on day one. But the more common approach is that we would argue that they became then a newly formed business and that they became an applicable large employer after. But the buyer is responsible to make sure that all reporting is done. So they always have to decide that. So the key takeaways is that we are in uncharted territory, even after 8 years until more guidance is released. So again, these are just the various scenarios that we've seen and how they've been treated, but we do not have any definitives. But as you can see, there's arguments either way in certain scenarios, but it's something that if you are have a client that's going through an acquisition, these are the things that always need to be discussed with the lawyers in the acquisition. Please do not forget about the health plans. They get so carried away with all the other parts of the business that they want to buy or sell, but we always have to worry about where we stand with health plans as well. And corporate mergers and acquisition transactions of all sizes and degrees raise a lot of complexities and compliance issues under 4980H. Issues will vary depending on the specifics of each transactions, but the party to the transactions and their advisors should be prepared to consider these issues in the transactions due diligence and documented phrases. They still need to be aware of that. And take nothing for granted when it comes to the ACA, and document. And one of the other things that came up with one of our clients was that inadvertently they created a MIWA, and you want to avoid that at all possible costs as well. Whereas they did an asset sale, they basically turned all the employees over to the new group, but they said that they would continue under the old group benefits. And then they said, but the new group was responsible for reporting. So when it came to reporting, they've got a plan that is, over here. And we had employees that were not employees, but getting a health plan of a non-employer plan. And it really was a mess the way that all went down. So again, we've got to document, we've got to think of everything. And whenever a client mentions a merger and acquisition, their attorneys really need to be aware of all the challenges we have with employee benefits and with the Affordable Care Act. So with this, I think Mara is going to launch a poll question that we have for you while we see if you guys have any questions regarding this. And the poll question that she is launching is, would it be of interest if an ACA webinar on acquisitions and measurement periods was actually conducted? What happens if you have an acquisition and you've got applicable large employers and they have different measurement periods and then employees are transitioned? How does that work? And it also is always beneficial to know how those rules work, because we actually do have rules. If you want to change measurement periods mid-year, or if you want to change measurement periods of employees. So if you're interested in this kind of webinar, let us know, and we would be glad to prepare one. And I think 96% of you say yes, and only 4% of you said no. So I guess we're going to be preparing a webinar. Stay tuned on ACA measurement periods and acquisitions. So with that, Mara, do we have any questions?
Let's see here. I see one question. Do you have any suggestions for PCOR fees? We have a client that acquired a company that had a self-insured health plan effective March 1st, who handles the reporting and paying for the plan before our client took over the plan. So a couple questions.
Yeah. Well, again, you're going to have to look to see whether it was a stock or an asset. Because if it's a stock, the buyer is going to have to take over those PCOR fees. If it's an asset, all depends on what assets are out there and who's going to be doing what. So first thing you have to determine is what kind of sale it's going to be, and then going from there with the PCOR fees, very similar to what we have here. Aren't you all going to be excited when the PCOR fees go away in 2029 and we don't have these anymore? Hopefully they won't be extended again, but it got us out of the Cadillac tax. So we have to be happy about not having Cadillac taxes, but it's good that the PCOR fees are coming to an end, hopefully shortly. 5 more years and we're done. 4 more years and we're done.
They had a follow-up to that question saying, assuming PCORI isn't extended.
Okay, well, yeah, we still have to, this year it would be, it's still in effect. Let me look at that PCOR question and I'll get back to you, okay?
Okay. We had another one that just came in. Can you clarify COBRA in both scenarios? Also, employees currently under an FMLA open claim.
Okay. When you have COBRA, and it's an asset sale, basically the way the law is written for COBRA and asset sales is if the plan continues under the seller, and the seller still has an active group health plan, then COBRA is offered under that active health plan. If the plan does not, if they don't have a plan under the seller, and they don't maintain an active plan under the seller, but the buyer has a plan, then the way the law was written, COBRA goes to the buyer, and they have to offer them COBRA under the buyer's plan, and they get to make that election under what the terms and conditions of that buyer's plan is, as if they were an employee under the buyer's plan. Very similar to open enrollment. They would have an open enrollment to choose that buyer's plan and to make their choices out of the buyer's plans. If neither the buyer or the seller have a group health plan, then there's no COBRA. COBRA dissipates. Now, on a stock sale, they are, I believe, and I have to look it up and I'll get back to you on this on COBRA. I believe that they would go to the buyer's plan, but I'm not 100% sure until I look it up, because they're not ongoing employees. They've terminated, but I just want to make sure on the stock sale that they go to the buyer's plan. They might not, because there might not be that liability, but I'll look at it on the stock side and get back to you on that. But on the asset side, you look to see who has the plan. It starts with the seller's plan, they would continue. If they're not, it would go to the buyer's plan. And if no plan, then they're out of luck.
Thank you, Michelle. At this time, I don't see any additional questions.
Okay, well, thank you all for attending today. Mara will be sending me those questions in writing so that I can get back to you, and she will send them out to the participants in this presentation. So thank you all, and we will start working on an ACA measurement period webinar. I know we have another webinar coming up shortly on ACA. And Mara, do you want to remind them of the date and what the topic is?
The next ACA webinar is going to be on July 2nd. It's going to be the same time as this one, 11:30. And then it's going to be ACA testing your knowledge.
Okay. And then we'll just add the fourth to the series on the ACA measurement periods and acquisitions. So stay tuned.
Thank you, everyone. Have a good day.
Thank you.